Time in accordance with rules of procedure, second reading debate is adjourned and the bill is referred to the House Committee.
This Council resumes the second reading debate on the Criminal Procedure Amendment Bill 2023. Ms. Yong Ho Yan, Chairman of the Bills Committee on the bill, will first address the Council on the committee's report. Ms. Yong. Mr. President, as Chair of the Bills Committee on Criminal Procedure Amendment Bill 2023, I table this report into the Council. The bill seeks to amend the Criminal Procedure Ordinance, Cap 221, to introduce a statutory appeal mechanism for the prosecution to appeal against no-case rulings made by the Court of First Instance in criminal trials with a jury, as well as verdicts or orders of acquittal given in cases concerning offences endangering national security tried in the Court of First Instance without a jury by a panel of 3 judges under Article 46 of the Hong Kong National Security Law. The Bills Committee has held 2 meetings with the administration. Members generally support the bill. Some members, however, consider that the administration's publicity and explanation on the bill is of paramount importance in gaining support from the general public, especially when the bill concerns criminal cases involving offences endangering national security, which are sensitive from the public's perspective. This is not easy for the public to understand the bill. Some members suggest that the administration use plain language, infographics, or flowcharts to illustrate the appeal mechanisms proposed in the bill. It is also suggested that the administration provide statistical data, precedents, or foreseeable cases to illustrate the seriousness of the miscarriage of justice which may take place in the absence of the appeal mechanisms proposed in the bill. Reckoning that the bill concerns complicated and technical legal issues, the administration concurs that it should step up efforts in explaining the bill to the public. Some members have asked whether the proposed appeal mechanisms would give rise to a public perception that the defendant's rights and freedom would be eroded. They have asked how the administration would safeguard the rights of defendants who have already been acquitted. The administration advises that the bill only provides appeal procedures, and whether an appeal lodged by the prosecution is successful is determined by the Court of Appeal taking into account relevant legal principles and evidence adduced. The rights of the defendants who have already been acquitted before the enactment of the bill would not be affected, as the proposed appeal mechanisms would not apply to rulings, verdicts, or orders made or given before the bill's enactment. The appeal mechanisms would not contravene the principle against double jeopardy. The rights and freedom currently enjoyed by the defendants, including their right to a fair trial, would continue to be well protected. With regard to the reason and effect of the proposed acquittal guarantee given by the prosecution for the purpose of appeal under the proposed no-case-to-answer appeal mechanism, the administration advises that since the judge has already given a no-case ruling, the defendant should be acquitted when the prosecution lodges an appeal, but the Court of Appeal refuses to grant leave to appeal or the prosecution abandons the appeal. The proposed acquittal guarantee would put the defendant back to his or her original position before the appeal in such circumstance. If there is no acquittal guarantee, it is technically possible that the prosecution could stay the current proceedings and recommence proceedings for the same offence in the future, which is not desirable. Some members are concerned whether there is a time limit for the prosecution to lodge an appeal against a no-case ruling. The administration explains that the bill provides that the Secretary for Justice must do the acts required as soon as practicable to make an appeal. It allows suitable flexibility to cater for the varying circumstances of different cases. The intention of the provision is not to allow as much time as possible for the prosecution to consider whether to appeal or not. Once the Court of First Instance rules that there is no case to answer, the trial judge will normally proceed to direct the jury to acquit the defendant immediately, or if the jury have been sent away, as soon as they can be summoned back to court. If the prosecution intends to appeal against a no-case ruling, it must act expeditiously before the trial judge proceeds to direct the jury. Apart from informing the Court of First Instance immediately after a no-case ruling that it intends to appeal, the prosecution could request an adjournment to consider whether to appeal, for instance, in circumstances where the prosecutor is a briefed-out counsel and directions have to be sought from the Department of Justice on whether to appeal. The proposed provision stipulates that the court must grant an adjournment until at least the next business day, and the no-case ruling would have no effect until the expiry of that period of adjournment. since the no-case ruling would resume its effect once the adjournment expires, thus leading to an acquittal by the jury, there would be an urgency for the prosecution to decide whether to appeal. On no case to answer appeal mechanism, some members have queried the need to restrict the reports of appeal proceedings, how the proposed restrictions would apply if the person publishing the report is not in Hong Kong, whether reports published on the internet would be covered, and whether there are existing statutory provisions that mandate the removal of such a report from the internet. The administration explains that the intention of imposing such restrictions is to ensure that the jury would not be exposed to information about the appeal against the no-case ruling if the defendant is retried before the same jury after the appeal, so that fairness of the trial can be guaranteed. The bill provides that reports containing certain basic information of the appeal are allowed, while grounds on which a no-case ruling may be erroneous are not allowed to be reported. If a person outside Hong Kong publishes such a report and enters Hong Kong afterwards, enforcement action can be taken. If the jurisdiction where the person is located when they publish the report has an agreement for surrender of fugitive offenders with Hong Kong SAR, the case will be handled according to the agreement. Written report covers also materials on the internet. There are no specific statutory provisions that mandate the removal of information or material that contravenes the reporting restrictions from the internet. If a contravention is detected, the prosecution and/or law enforcement agencies would demand the online platforms or forums or internet service providers to remove the report forthwith. If necessary, the government can apply for an injunction in aid of the criminal law to prohibit disseminating, circulating, publishing, or broadcasting the report. In breach of the injunction is punishable as a contempt of court. The administration has indicated that an amendment will be moved to expressly provide for the mode of service of documents on the defendants or respondents under the proposed National Security Law Article 46 appeal mechanism. The Bills Committee has no objection to the proposed amendment. The Bills Committee has completed its work, and details of the deliberations are set out in the report submitted to LegCo. Mr. President, I'd also like to offer my views on the bill. As reported just now, the amendment bill concerns amendments to the procedures to address the shortcomings in the current criminal proceedings to avoid unfairness. I support the amendment bill because fairness is of paramount importance in our legal system. If there are loopholes in our system, they need to be plugged, especially in events of cases involving national security. This amendment bill involves the CFI judge handing down an erroneous ruling and the appeal avenue available to the prosecution. First, the prosecution can appeal against the no case to answer ruling made by the court of first instance. There is also another NSL 46 appeal proposal. That is, the prosecution can appeal by way of case stated against a verdict or order of acquittal given by the CFI, constituted by a 3-judge panel to try a case concerning national security. I think that the Secretary on his website has provided infographics to illustrate these principles, and let me reiterate them. The guarantee of a fair trial. This ensures that we have due process, fair proceedings, including the evidence to be adduced. And this amendment bill does not contravene the principle against double jeopardy. In terms of offences involving offences endangering national security, this is an avenue to correct the erroneous rulings so as to bring the culprits to justice. Third, we need to exercise judicial independence. We need to guarantee that there is judicial independence in the courts of Hong Kong SAR. So we are enhancing the procedures together with amendments to the no case to answer appeal procedures. And it is also a common trend in the common law systems to allow the prosecution to appeal in cases tried without a jury. First, I'd like to address the no case to answer appeal proposal. This is one way to address the erroneous rulings made by a CFI judge in the court of first instance in criminal proceedings. when a case is tried by a CFI judge with a jury, if the court considers that there is no case to answer for the defendant before giving this direction to the jury, and before this amendment bill, there is no avenue for the prosecution to lodge an appeal. In other words, the defendant will be acquitted right away. The defendant will not be tried again. The effect of the amendment bill is that once this ruling is made, if an error of the law is identified, the prosecution can then lodge an appeal. And if the appeal is successful, the defendant's trial will continue. In the course of deliberating on the bill, I asked the administration about details of the erroneous ruling or error in law. Now, according to the Department of Justice, they differ from case to case. There are also elements relating to the provisions in the national security law and also admissibility of evidence and the erroneous ruling thereof. In some cases, the court may also make the ruling such that it was unreasonable for the judge to have made. So in such circumstances, the prosecution should be allowed to appeal. And under the appeal mechanisms, the prosecution should indicate to the court that it intends to appeal the no case to answer ruling. Now, in such cases, an acquittal guarantee will be provided by the prosecution. In other words, if the prosecution cannot successfully obtain leave from the Court of Appeal to appeal or abandons the appeal, the defendant will be acquitted under the acquittal guarantee. Now, there is also another proposal on restrictions of reports of the appeal proceedings under the no case to answer appeal proposal. The name of the judge, witnesses, defendants, the relevant offences, bail arrangements, etc., can be reported, but the grounds on which the prosecution is lodging the appeal cannot be reported. I think this is one way to avoid causing prejudice to the defendant and avoid affecting the jury. The other proposal relates to national security cases. For a trial by a panel of 3 judges at the CFI without a jury, if the defendant is found not guilty before the amendment bill, the defendant will be acquitted because the prosecution cannot lodge an appeal. And under the principle against double jeopardy, the defendant will not be retried. And under this proposal, the prosecution can indicate their intention to appeal, and then meanwhile, the defendant may be granted bail or remanded in custody. Within 14 days, the prosecution should, by way of case dated, lodge an appeal with the Court of Appeal, and then the ruling can be confirmed, reversed, or varied by the Court of Appeal. Before the bill is proposed, if the judges made an error in the ruling, there is no avenue for the prosecution to appeal, and this is unjust. Now, during the deliberation, the Bills Committee considered the principle against double jeopardy and whether this appeal mechanism goes against this principle. The Department of Justice has given a clear explanation. In relation to Hong Kong Bill of Rights, Article 11 and Article 5 of the NSL, no one shall be liable to be tried or punished again for an offence for which he has already been finally convicted or acquitted in accordance with the law and penal procedure of Hong Kong. This is the principle against double jeopardy. The crux of the matter is whether the defendant has already been finally convicted or acquitted. Now, in the CFI stage, it is not regarded as a final conviction or acquittal. In other words, the defendant can be retried under the appeal mechanism, and this is not a contravention of this double jeopardy principle. And in fact, this is not something new. At the magistracy and the district court levels, there is already an appeal mechanism for the prosecution to lodge an appeal with the appellate courts. So I find this amendment bill appropriate. In conclusion, I think there is a need to introduce these appeal proposals in the amendment bill. They are legitimate, reasonable, and timely. Now, if there is an apparent error in the judge's ruling, at present, there is no legal avenue for the prosecution to lodge an appeal. This loophole should be plugged. In terms of legitimacy, according to the Hong Kong Bar Association, in other common law jurisdictions, there is a trend of providing for an avenue for the prosecution to appeal against these cases. So we're just catching up with the trend. For national security related offenses, the prosecution can appeal by way of case stated against the order of acquittal given by a 3-judge panel of the CFI. This is modeled on the magistrate's ordinance and the district court ordinance. This is an effective and established practice. It is also legitimate. I think that the introduction of these appeal mechanisms can help safeguard the rule of law and also national security. The Hong Kong national security law has been implemented for 3 years. We have restored order in society. The Hong Kong SAR government is tasked with making a sustained effort to safeguard national security. This is a technical amendment. Still, we need to plug the loophole as quickly as possible. This is not a one-off exercise. In terms of enhancements to the national security law in the past few months, the Secretary for Justice also floated another bill. For legal practitioners, the bill was passed, and that plugs the loophole for expatriate counsel to take up cases involving national security. So the loophole has been plugged. I hope that the government can make a sustained effort to further improve national security law so as to plug all the necessary loopholes. Finally, just 10 seconds. I see that the government has made continuous improvements in terms of publicity. I hope that the government can ramp up its efforts for the public to better understand the bill. I so submit.
Mr. Jimmy Ng, thank you, Madam Deputy. I would like to express my support for this Criminal Procedure Amendment Bill 2023 tabled by the administration. In October last year, the President Xi Jinping gave important address on improving the national security legislation in Hong Kong, and the relevant improvement is the key of the matter. This amendment bill is a measure to respond to the aspiration of the central authorities and make improvement to our legal system and the judicial system so as to continuously improve the national security system. This will provide systemic safeguards and should be supported by the community. According to Article 46 of the National Security Law, if there is a question of protecting the safety of July or the relevant integrity of the case, there a direction can be made where no jury is going to be empaneled. So if it's a case tried by a 3-judge panel in the CFI, and in the course of the case, the panel can make a ruling of no case to answer, and the defendant will be acquitted. At present, in the magistrate's court or in the district court, if the magistrate or district court judge makes a legal error on acquittal, the prosecution can lodge an appeal. But for more serious cases involving national security, there is no channel for the prosecution to lodge an appeal. This is an anomaly that has to be addressed. So the amendments are introduced to amend the Criminal Procedure Ordinance Cap 221 so that the Secretary for Justice can lodge an appeal in the case of where the CFA has made a no case to answer ruling. And in respect of national security law cases, the bill will allow the prosecution to appeal by way of a case stated if the judges have made an unreasonable ruling of acquittal. I'd like to thank the administration for their detailed elaboration and clarifications concerning the no double jeopardy principle. This bill is really about the procedure. Whether the appeal is successful or not will be up to the appellate court on whether sufficient evidence has been adduced and whether the CFI has made an error in law. Therefore, for those who are not yet the defendants who are not yet convicted, their rights to a fair trial and other rights will be safeguarded. I have to point out that in October 2022, the Court of Appeal make a ruling saying that there are lacunae regarding such rulings, and there will be a great benefit to learn from the UK experience. The Secretary for Justice, in view of the difference in our judicial system, we did not copy all the measures in the 2003 UK Act concerning such appeals. This has demonstrated that our system does have Hong Kong characteristics. I'd like to thank the Secretary for Justice for introducing this bill to bring about more justified system and to enhance judicial fairness. The amendments will certainly enhance international investors' confidence in Hong Kong's legal system, and they will be more willing to invest in Hong Kong. With this remark, I support the bill. Mr. Chan Siu Hong, I support the Criminal Procedure Amendment Bill 2023. Well, this bill is about the introduction of an appeal system for certain cases. The prosecution under this bill would be able to lodge an appeal against ruling of no case to answer. And also, in respect of a case adjudicated by a three-judge panel without a jury under Article 46 of the National Security Law, the prosecution can appeal by way of case stated for an acquittal. And since these are very serious offenses, under the existing system, the lack of an appeal mechanism would create lacuna which can be difficult to address. And the acquitted defendant under these circumstances cannot be tried again. And therefore, under the current system, the prosecution is not allowed to lodge an appeal even if the three-judge panel has made an error in law, and there will be a lacuna. So it's necessary to introduce the amendments, and it's a proper response to address the current shortfall. As for the suggestion that this is against the double jeopardy principle, I think such criticism is unfair. Under the BORO, the section 11(6), anyone who has no one shall be liable to be tried or punished again for an offense for which he has already finally convicted or acquitted in accordance with the law and penal procedure of Hong Kong. But this is an important legal principle. Because we have to protect and ensure the finality of court judgment and to safeguard the judicial system. But the no double jeopardy principle is that the accused has already been finally convicted or acquitted. In our system, we have the common law and the law of equities, and when a judge gave a direction in law to the jury, and the jury is responsible for the facts, for the judging fact. Therefore, under the common law system, the ruling of the jury is final. But the judge ruling of no case to answer is not a final ruling. Under the national security law, there are two ways to try a case involving national security law. One with jury, and the other is that the Secretary of Justice, in order to safeguard the official secrets, give a direction that the CFI should try the case without jury. And there will be a three-judge panel for such a case. As the judge, Honorable Li Yunteng, said in a case last year, Hong Kong national security law has created a new mode of criminal trial. That is to say, the CFI three-judge panel will be responsible for both the facts and the law. But whether the no case to answer ruling made by such a panel is final is not clear. At present, in a criminal case tried in the magistrate's court or criminal law, the prosecution can lodge an appeal by way of a case stated, so that the CFI or Court of Appeals view can be sought on questions of law. But in the current criminal procedure ordinance, there is no such procedure for the CFI. So if there is an anomaly, and then the prosecution is unable to lodge an appeal on question of error in law, there will be a lacuna. So also for national security law cases, they are new to Hong Kong. And also the appeal is really going to be handled by the appellate court. There's no way of getting second bite at the same cherry. I support the bill.
Ms. Elizabeth Court, the report to the 20th National Congress provides a dedicated chapter to modernize the law-based governance and safeguard national security. In terms of national security, it is not just about risk assessment. The country's sovereignty, security, national interests, they are of paramount importance. One of the objectives of this amendment bill is to provide for an appeal mechanism for cases involving the NSL for Article 46 for cases tried by a three-panel judge at the CFI without a jury on offences endangering national security. The prosecution can appeal by way of case stated against a verdict or order of acquittal. I think this is a necessary and legitimate amendment to the legislation. Now, the national security cases are tried at the Court of First Instance at the moment. If there is an error in the judge's ruling, since at the moment there is no avenue for the prosecution to lodge an appeal, these defendants will be set free. So this is a dire consequence, and the loophole should be plugged. The amendment bill allows us to review the procedure, because during the appeal, the Court of Appeal can consider the judge's ruling so that the government can fulfill its responsibility of preventing, suppressing, and punishing acts of endangering national security. I support the Criminal Procedure Amendment Bill 2023. Now, Madam Deputy, there are some views that the prosecution is a sore loser, and it goes against the principle of double jeopardy. I think that these demagogues outside of Hong Kong are trying to sling mud on the Department of Justice, claiming that this bill will destroy the well-established rule of law in Hong Kong. I cannot agree. According to National Security Law, Article 5 and the Hong Kong Bill of Rights, Article 11.6, no one shall be liable to be tried or punished again for an offence for which he has already been finally convicted or acquitted in accordance with the law and penal procedure of Hong Kong. And that is the principle against double jeopardy. The crux of the matter is whether this person has already been finally convicted or acquitted. Now, for a case tried by the Court of First Instance, this is not a final ruling. If the Court of Appeal overturns the CFI ruling, then there is no final conviction or acquittal to speak of, and no contravention against the principle against double jeopardy. Now, in the proposed mechanism, the prosecution can appeal by way of case dated. At the magistrates' courts and district courts level, prosecution has all along been able to appeal by way of case dated. Now, this, in terms of cases tried by the CFI by the 3-judge panel without a jury, the proposal is modeled on the established mechanism. If the Court of Appeal finds the ruling problematic, it should reverse or vary the ruling for the trial to be recommenced. The amendment bill will not affect the case tried by CFI judges with a jury. It does not contravene the principle against double jeopardy, but rather it is a respect for the legal system in Hong Kong. Now, for accusations that this proposal will allow the prosecution to incessantly go after acquitted defendants, this is unfounded. As for other attacks on the national security law, comparing to Singapore and Malaysia, these common law jurisdictions have even harsher national security laws. Now, these two governments can detain on an administrative basis any suspect of terrorist activities up to 2 years, and that this administrative decision cannot be judicially challenged. Whereas in Hong Kong, our provisions are very relaxed. Article 4 of the National Security Law refers to the International Covenant on the Civil and Political Rights, and this guarantees fair trial for the defendant. Now, for accusations of this amendment bill eroding the rights and freedom of defendants in the common law system, this accusation is unfounded. Those who utter these accusations have ulterior motive. They want to condone those offenders of national security law to be able to escape. We need to have law-based governance in order to safeguard the people's livelihood. This amendment bill can effectively plug the loophole and allow justice to be done. Only when we have national security will Hong Kong be able to set sail far and steady for the great rejuvenation of the Chinese nation. Ms. Carmen Can. I speak in support of the Criminal Procedure Amendment Bill 2023. As a member of the Panel on Administration of Justice and Legal Services and Deputy Chair of the Bills Committee, on both occasions I pointed out that amendments to the Criminal Procedure Ordinance Cap 221 can help plug the existing legal loophole or lacuna. So what lacuna are we talking about? The Bills Committee completed scrutinizing the bill last month. This bill is rather technical. Well, only one with ample understanding of the criminal procedures would understand the details of the bill. I advise the government to provide infographics and flow charts to explain the difference between the two proposal mechanisms, the grounds for putting forward this appeal, and the comparisons before and after the bill's enactment. And I'm happy to see that the Secretary has provided 10 infographics to illustrate the salient points. For example, what is meant by case dated, what is meant by an error in law. My concerns have been addressed with these illustrations so that we can better understand the bill. I welcome the government's effort. First, I'd like to talk about the no case to answer appeal proposal. If the bill is passed, In accordance with Article 46 of the National Security Law, the prosecution can appeal by way of case stated against a verdict or order of acquittal given by a court of first instance constituted by a panel of 3 judges to try a case concerning offenses endangering national security without a jury if the prosecution is of the view that the panel has made an error in its ruling. Now, there is an anomaly in the existing system. Once the defendant is found not guilty by the court, even if there is an apparent error, at the moment there is no avenue for the prosecution to launch an appeal. Now, what is meant by an error in law or an error of law? For example, an error in the interpretation of legal provisions or wrong omission of inadmissible evidence, so on and so forth. These are errors of law. As you can see, there is a need to rectify the problem. Now, this is also in line with District Court Ordinance Cap 336 and also Cap 105 Magistrates Ordinance. There are established mechanisms for the prosecution to appeal by way of case status against an erroneous ruling made by a judge at these 2 levels of the court. There is an absence in the court of first instance procedures. So this is a stark contrast. Why is it that for the lower courts, the prosecution is given an avenue to appeal, but not so at the high court? At the Bills Committee meeting, the Department of Justice explained that in order to uphold justice, the prosecution should be allowed to lodge an appeal so as to allow the Court of Appeal to review the decisions made by the Court of First Instance judge in trying cases involving national security for the effective prevention, suppression, and punishment of acts endangering national security. Madam Deputy, I want to emphasize that with the Bills Committee's deliberation and feedback from the 2 legal professional bodies, the Department of Justice has explained to us that there is no prejudice against the principle against double jeopardy, the rights and freedom of the defendant, and the defendant's right to receive a fair trial. The bill has no retroactivity. It only applies to proceedings commenced after the bill's enactment. I'd like to turn to the next appeal proposal in the bill, and that is no case to answer appeal proposal. In February, the Department of Justice at the AJLS panel put this proposal forward so that this appeal mechanism can be established in normal criminal proceedings when the Court of First Instance judge made a no case answer ruling. The prosecution will be given a chance to appeal. Now, let me explain the background. On the 28th of October last year, Ray, Secretary for Justice's reference number 1 to 3, the Court of Appeal made this ruling. The Court of Appeal overturned the ruling made by 2 CFI judges. Now, it is of the view that the judges usurped the function of the juries and incorrectly withdrew the cases before their respective juries could consider them, thereby causing serious miscarriage of justice. However, because of the absence of a timely appeal mechanism, these 2 defendants acquitted already left Hong Kong. Now, at the moment, because of absence of this appeal mechanism, it leaves much more to be decided. The Department of Justice consulted the stakeholders, including the 2 legal professional bodies. They support this amendment bill. They've also provided views in relation to different matters, and at the committee stage, the Department of Justice will be moving an amendment. This is a technical amendment on the surface of documents to safeguard national security and safeguard judicial independence. As Deputy Chair of the Bills Committee, I took a very serious view in scrutinizing the bill. I also support the Department of Justice to address this anomaly as quickly as possible. The Department of Justice should also ensure important principles can be safeguarded, such as presumption of innocence until proven guilty. Last year, the presidency delivered key remarks on the 1st of July. In the 4 months that he put forward, he mentioned the common law system. In terms of safeguarding our unique advantages, he said that we should safeguard the common law system. The report to the 20th National Congress also speaks on the same point. Now, what is meant by our common law system? The common law system is a life system that will allow for continuous improvements. Now, even if there is an anomaly in a judge's ruling, in the event of this legal lacuna arising, an amendment bill should be put forward to address the issue and amend the ordinance. And this is the feature of the common law system. However, if there is still infighting and filibustering within this council, how can we give play to our unique advantages? Even if the Court of Appeal judges has made these observations, we will not be able to plug the loopholes. Now, with the improved electoral system, the Legislative Council can effectively scrutinize the bill, and this is how we give play to our advantages in a legal system. In order to take forward development in all respects in Hong Kong, we need to safeguard the advantages of the common law system in Hong Kong so that we can give play to the advantages of the system, such as flexibility and continuous improvement, so that in the area of patriots administering Hong Kong, we can give play to the advantages of common law system to ensure stability and prosperity of Hong Kong. I so submit.
Mr. Rock Chen, Madam Deputy, I speak in support of the Criminal Procedure Amendment Bill 2023. The Secretary has proposed to amend Cap 221 Criminal Procedure Ordinance so as to fill the legal lacuna, and has come up with 2 specific provisions concerning appeals. One is in relation to Article 46 of the National Security Law in relation to appeals against offenses in relation to acts endangering national security. No one can be safe from mistakes. Now, if the court of first instance commits an error of law, if the prosecution lacks an avenue of appeal, then it means that defendants who endanger national security will be escaping the long arm of justice, and it means that we are not able to safeguard national security. Therefore, the loophole should be addressed. The current proposal means that the Criminal Procedure Ordinance can be enhanced. In fact, the prosecution can lodge an appeal in relation to the no case to answer appeal, and we can more effectively prevent and suppress conduct endangering national security. It means we are taking the initiative to address the shortfalls in our legal system. In other words, we are filling the lacuna. It shows that we are trying to make sure that we can administer justice. It is reasonable and timely. Well, we would like to safeguard national security. We want to safeguard the one country, two systems. We want to protect the community at large. When the NPC made the NSL, it is prevailing. In other words, when our provisions are out of step with the NSL, we should give priority to the NSL. The SAR government should take the initiative to make sure that local laws are enhanced so that they are consistent with the NSL. In the year 2020, the NSL was promulgated, and the government has been examining our existing legislation to make sure that our laws are in line with the NSL. Therefore, I believe that the DOJ's proposals to amend the law are in line with our legal system. It is a matter of respecting our legal system and reasonably legitimately fill the lacuna that we have identified in the implementation of the law, and we make use of the system to address the difficulties that we face. This is to improve the criminal procedures in relation to appeals, making sure that the criminal justice system is fair. And for the controversial NSL cases, we are providing an effective avenue of appeal. So I spoke. Mr. Martin Leong, Madam Deputy, let me declare, first of all, that I'm a practicing barrister in Hong Kong in accordance with the existing law. At a court of first instance, when there's a criminal case with a jury, before the jury has the opportunity to consider the facts of the case, the judge may say that there is no chance that the evidence would convict the defendant, will make a ruling that there's no case to answer, and the defendant will be acquitted. This is regarded as a final acquittal. Even though in the course of the hearing there might have been an error of law, and the prosecution can never have a chance of appeal. In other words, this is an irreversible miscarriage of justice. Well, this is a miscarriage of justice. It did happen last October in relation to 3 cases concerning international drug trafficking. CFI judges made a ruling of no case to answer, and then the CA decided that there was an error of law. That is, the case was withdrawn before the case was referred to the jury. And the CA was of the view that there was an urgent need to reform the relevant provisions. And in fact, for the United Kingdom, which also practices common law, as early as 2003, has already reformed the criminal procedures. In relation to the no-case ruling made by a judge, the prosecution may appeal immediately. In order to prevent miscarriage of justice, we must fill the gap as soon as possible. On the other hand, the prosecution cannot, in relation to a CFI panel formed of 3 judges, hearing cases concerning offences endangering SL, the prosecution cannot appeal against that, even when there is a verdict or order of acquittal. Well, in such cases, including NSL cases, if there is a verdict or order of acquittal, on other occasions, the prosecution may, by way of case stated, lodge an appeal that refers to the district court and the magistracies. It has been long established, and I don't think in relation to the High Court, in relation to CSI panel of judges, should be made an exception. Well, when there is an error of law, and if the defendant in an NSL case is to be acquitted, there will be serious consequences. We're not able to sort out the facts, we're not able to clarify the legal position, and in fact it will jeopardize our national security. This should be ratified ASAP. Madam Deputy, I have full trust in the professionalism of our judges, but then no human beings can avoid making mistakes. Therefore, in order to make sure that justice is done, we would like to see the proposals carried out. For the Criminal Procedures Amendment Bill 2023, the aim is to address the existing lacuna so that for the no-case ruling made by CSI, as well as a verdict or order of acquittal made by CSI panel of 3 judges, the prosecution may lodge an appeal. In other words, for both the defense and the prosecution, they will equally enjoy an avenue of appeal. The prosecution, of course, can only lodge an appeal under specific circumstances. In other words, we are enhancing the procedural justice in criminal cases, and it means that we are moving with the times and we are filling the gap. At the same time, the bill has already imposed reasonable restrictions on the two mechanisms. For the first one, the prosecution must provide an acquittal guarantee. That is, if the leave to appeal is not granted, or if the DOJ is to abandon the appeal before a determination is made, then the defendant must be acquitted. And then if there is a question of law or there is an error of law or principle, then the original ruling can be reversed or varied. And then after the prosecution has informed the court of the intention to appeal, then within 14 days or within a longer period as granted by the court, then a case-dated appeal would be allowed. Madam Deputy, allowing the prosecution to make an appeal, to lodge an appeal, because there's an error of law or principle, I think this is in line with the legal reform in common law jurisdictions. Well, many stakeholders, including law schools, are in support of the proposals. The two amendments are procedural in nature. There's no retrospectivity. It doesn't go against the principle of a principle against double jeopardy, and I don't think our independent adjudication powers are affected. Some people have said that with this amendment, under the NSL regime, 100% of the cases will be will have a result of conviction. I think this is unjustified, unsubstantiated. It is a procedural matter. We are not targeting at any specific defendant. When the CFI or the CFI panel commits an error of law, then there will be a grant of leave to appeal. If the CA doesn't believe that there is sufficient ground to appeal, then there will be no leave to be granted, and then the defendant will not be sort of affected. Well, I believe that it is necessary, timely, and legitimate. It is there to safeguard our good reputation as far as our legal system is concerned. And then for criminal cases in relation to NSL, they are of course sensitive in the eyes of the public, and they are more professional and technical. Members of the public may find it difficult to understand. The administration should enhance the publicity and explanation about the provisions. Madam Deputy, I support the bill, so I spoke.
主席，2023年刑事訴訟程
Mr. Teck Chi Yuen, Madam Deputy, the introduction of the Criminal Procedure Amendment Bill 2023 has caused some concern. At first, some people were worried that this would affect the existing legal system, and also our rule of law would be adversely affected. Hong Kong people attach importance to our legal system, our court system. Hong Kong is an international financial center. Investors must get sufficient safeguard for their investment, and legal consequences of our law should be foreseeable and certain. Therefore, certainty of our law that would promote our economic development. And the rule of law is an important element of our prosperity. This would ensure people's compliance with the law and confidence so as to achieve social harmony and to prevent the deterioration of social atmosphere into chaos. According to the basic law, the rights of Hong Kong people are well protected. The rule of law ensure that our rights will not be infringed upon. Therefore, when the the government tries to change the legal system and the law, people are rightly concerned. In the face of changes to our complicated legal system, caution should be exercised by the administration. There should be better communication and follow-up explanation offered to the public so as not to complicate things unnecessarily. The bill would empower the Secretary for Justice to lodge an appeal in certain cases. There were certain queries raised at first. First, whether it will violate the double jeopardy principle. Second, would the amendments change the principle of innocent presumption? And also, whether this will affect the court's judicial power. Members raised some concern during the deliberation in the Bills Committee. I believe that the officials did give very elaborate and detailed explanation. The bill would allow the Secretary for Justice to lodge an appeal in certain cases. Whether the appeal is upheld is up to the court. If the court thinks that the appellate, the reasons to substantially support the appeal are not good, there will be no retrial. So this will not go against the double jeopardy principle. And also with the acquittal guarantee given by the Secretary of Justice, the rights of the defendant whose cases have yet to be finally adjudicated will not be affected. As for the national security law, the 46 appeal cases, the right to appeal, the right to bail will not be affected, or the bail system will not be made straighter. I do not quite accept the explanation of the officials. We still need time to digest the national security law since it's very new. Many people do not understand the legal complications, and therefore there should be more explanation and elaboration of the relevant legal issues. I hope in the future Article 23 legislation exercise there should be more thorough introduction and elaborations to inform the public. With these remarks, I support the amendments. Mr. Chan Chun-ying, the purpose of the amendment is to address the lacuna in case where the CFI judge has made a no case to answer ruling, and also in respect of the panel of judges making an erroneous ruling in case of national security law cases, and there's no redress for the prosecution. At present, when the case is tried in the CFI with a jury, the judge will make directions in accordance with the law and direct the jury to come to a conclusion, to convict, or after the direction is given to the jury, if there's a no case to answer ruling is made, there is no way that the prosecution can lodge an appeal. And also according to Article 46 of the law, of the National Security Law, the Secretary for Justice may issue a certificate directing the case shall be tried without jury on grounds of such things such as issues such as protection of state secret and protection of personal safety of jurors and the family. And in this case, there will be a free judge panel trying the NSL cases. At present, in criminal cases tried in the magistrate's court or district court, if the relevant judge or magistrate make an error in law, the prosecution can lodge an appeal by way of case status. But for more serious cases of CFI, national security law cases, the prosecution is not allowed to lodge an appeal. That we should address this anomaly. So this bill bill would address the shortcomings in the current system. The bill would empower the prosecution to, with the leave to lodge an appeal, consulting a no case to answer ruling with the leave of the CFI or the Court of Appeal. And the no case to answer ruling can only be reversed on the ground of a legal error. And also for appeal cases lodged by the prosecution, the appeal can be made by way of stay cases, citing grounds such as the judge has made a legal error. Some members are concerned about whether this would affect the double jeopardy principle if there's a retrial. A retrial is not a second trial, but the appellate court would review the appeal in accordance with evidence and legal principles. The appellate court will look at the evidence, and only when it is satisfied that there's a error in law or effect before the ruling can be overturned. If the appellate court does not grant leave or the prosecution gives up the appeal, then the defendant will be acquitted or in the same way. So this will not affect the double jeopardy principle or the judicial independence. According to 2022, the International Justice Index, Hong Kong's ranking is very high. In the East Asia and Pacific region, we rank number 6. And among the global rankings, we are 22. This amendment would ensure that our very sound legal system can be further enhanced, and that would improve the confidence of investors around the world, and they will be more likely to invest in Hong Kong. Therefore, I support the Criminal Procedures Amendment Bill 2023.
Mr. Tony Chair, Madam Deputy, I speak in support of the Criminal Procedure Amendment Bill 2023. I'm not a legal expert. I'm not a member of the Bills Committee, but I'd like to speak from my heart and allay the concerns, the smearing and misunderstanding of the bill so that I can tell a good story of Hong Kong. Some anti-China elements have described this bill as making the Hong Kong national security law even harsher so that the prosecution can incessantly go after the offenders. They question whether there is a shortcoming in the Hong Kong national security law and that the administration is hastily making up for its mistake. All these accusations are wrong. This amendment bill entails two proposals. One is to lay down statutory appeal procedures for the prosecution to appeal against rulings of no case to answer made by the Court of First Instance in criminal trials with a jury. It is called no case to answer ruling. This legal lacuna had existed for some time. It has nothing to do with the Hong Kong national security law. Now, the amendment is not floated until now. As I understand, last year there were 2 drug trafficking cases. The trial judges acquitted the defendant there and then after handing down a no case to answer ruling for some technical reasons. And it was a rare occasion in which the jury in court questioned the judge's ruling. However, under the current criminal procedure ordinance, the prosecution is not given an avenue to lodge an appeal and ask for the defendant to be retried. In cases where the defendants are apparently guilty, they can go scot-free because of the errors made by the trial judge. Now, for the defendants in these two drug trafficking cases, immediately after the no case to answer rulings, they left Hong Kong. It is under this backdrop that this amendment bill is proposed to allow the prosecution to appeal. There are two outcomes to the appeal. The prosecution may not necessarily secure a conviction. However, this at least provides another safeguard instead of leaving the matter with just a single trial judge to give a final ruling. I support this amendment bill. As pointed out by the administration, the Criminal Procedure Ordinance is modeled on the UK Act, but the UK Act has been amended long ago to plug this loophole. This amendment bill is now floated to address the lacuna in the ordinance, so the accusation is unfounded. The second part of the bill has a similar appeal mechanism. Now, for court of first instance cases, they're usually tried with a jury, and the prosecution can lodge an appeal for a ruling with an error. And the Court of Appeal may direct that the case be retried without contravening the principle against double jeopardy. However, for national security cases tried only by CFI judges without a jury, then for whatever reason, if the judge finds the defendant not guilty, there is no avenue for the prosecution to appeal against this decision. Only the convicted can lodge an appeal, in other words. Now, even in an ordinary criminal case, there is this perception of unfairness, not to mention that this case involves national security. It is only right that an appeal mechanism be set up for the prosecution to appeal against these national security cases. It doesn't mean that the prosecution will necessarily secure a conviction. It provides an additional way to rectify mistakes. For example, in a recent case involving the substandard construction works, there is common refrain that the court has handed down a very lenient sentence, and the prosecution is allowed to lodge an appeal. Now, the Hong Kong's common law system stems from the UK's legal system. This is common knowledge, but it doesn't mean that our legal system is perfect and no improvement is needed. I hope the Department of Justice and the government will be visionary in reviewing the various legislation and regimes in our legal system, especially when it comes to matters concerning national security. In light of the new era and new developments, we should continue to make improvements. I so submit. Mr. Dennis Lau. Thank you, Madam Deputy. I speak in support of the Criminal Procedure Amendment Bill 2023. I'm a member of the panel on Administration of Justice and Legal Services. I'm also a member of the Bills Committee. The truth always prevails. The legal system in Hong Kong should always be kept abreast with the times. Improvements should be made, mistakes should be rectified if necessary. Our system should be able to allow us to be impartial, just, and be able to punish those who are in the wrong. Well, we have 4 levels of court: Court of Final Appeal, Court of Appeal, Court of First Instance, District Court, and the Magistrates' Court. In the eyes of a layman, there should not be a departure in the procedures adopted by different court levels. Now, this amendment bill highlights exactly this departure or anomaly. This anomaly provide the stark contrast. In other words, the defendant is prejudiced. The system is skewed. The amendment bill seeks to address this legal lacuna. This is not an amendment bill that will deprive the defendant of their rights or make sure that they are convicted. I hope members of the public will understand the reasons for this bill. Now, this bill addresses two important legal lacunae. I am not a legal professional. It took me some time to read through the details of the bill. Now, for ordinary citizens, they may find the amendments really difficult to understand. In the Bills Committee, I mentioned that everyone should be able to understand the law in order for people to abide by the law. I urge the Department of Justice to prepare infographics to illustrate the details of the bill. I heard from Ms. Eunice Yung just now that the Secretary for Justice has already provided infographics in his blog. I welcome this effort. We need to act in the interest of our next generation. Actually, I prepared 3 slides to help myself understand the details, such as no case to answer appeal proposal, the NSL 46 appeal proposal, the salient points relating to the amendment bill. I tried to help my fellow party members understand this bill. The next step is for everyone to tell good stories of our legal system so that we all understand the laws of Hong Kong, so that we can make a joint effort in building Hong Kong into a regional IP training center and a center for international legal disputes resolution in the APAC region. On the 22nd of May, the AJLS panel had a meeting. The Secretary for Justice already explained the bill, and then in the second reading of the bill at the council meeting on the 31st of May, the Deputy Secretary already also explained this bill. We had 2 law schools, government departments, and other organizations providing their views on the bill. The majority of the views are in support of this amendment bill. They consider this amendment timely, legitimate, and reasonable. Members of the public should be reassured. They should have confidence in our legal system. The administration should not interfere with the judiciary. There should be more collaboration to go against criminals. The first element in this amendment bill is to address the legal lacuna of no case to answer appeal. At the moment, there is no avenue for the prosecution to appeal against rulings of no case to answer made by the CFI judging criminal trials with a jury. The lacuna is a result of a erroneous ruling of no case answer made by the CFI judge, leading to the release of the defendant. Because of the absence of an appeal mechanism, the defendant cannot be tried again. Now, the case can be stated at the Court of Appeal, but even if the error is confirmed, the defendant cannot be retried. According to the Court of Appeal, the judges concerned usurped the function of the juries and incorrectly withdrew the cases before the juries could consider them. So the loophole should be plugged. The second lacuna is an anomaly in relation to Article 46 of the National Security Law. In the event of a verdict or order of acquittal given by the CFI, constituted by a panel of 3 judges to try a case concerning national security without a jury under Article 46, the prosecution can now make an appeal. Well, although when the case is tried without the jury, the judge will explain the reasons for verdict, and that the error may be exposed. Still, because the prosecution is unable to lodge an appeal, the defendant can go scot-free. The prosecution, meanwhile, cannot appeal to the appellate court to clarify the fundamental legal principles. And this is the anomaly concerned in relation to the order or verdict of acquittal given by the CFI panel judges. In order to uphold impartiality and to effectively prevent, suppress, and punish acts endangering national security by the judiciary, the prosecution should be given this power to appeal so as to rectify the mistakes. Simply put, the Court of Appeal will be allowed to be the gatekeeper so that the proceedings will not just stop at the lower court, because a wrongful ruling will bring a more negative impact to society. But we're in the new era that the national security law is something new. There may be problems in its implementation. To make sure its implementation, local legislation should be amended in a timely manner so that with local legislation we can resolve problems arising from the implementation of Hong Kong national security law. I'm grateful to the SAR government for its effort. We had some really hard times, and now order has been restored. The truth always prevails. There is a need to enhance our legal system to address the anomalies in our legal system, with the aim to safeguarding national security, world peace, safeguarding individuals' rights and freedoms, so that Hong Kong can set sail far and steady under the one country, two systems principle. Our government can then focus on taking forward economic development to improve people's livelihood, to give people a sense of belonging, a sense of gain, and a sense of bliss, so that we can have sustainable development. I so submit.
Mr. Lai Tung Kwok, Madam Deputy, I speak in support of the bill. For the existing legislation, there are two loopholes involving the mechanism for the prosecution to appeal. It is but right to address the loophole, and so that we can administer justice. First of all, for the court of first instance, there's one judge hearing the case together with the jury. The defense at the end of the prosecution's case may ask for a ruling for no case to answer. Once the judge makes the ruling that there's no case to answer, then the jury will be directed to come to an acquittal decision. Even if the prosecution thinks that the judge is wrong, currently you may only lodge an appeal. You may only ask for clarification from the Court of Appeal when there is an error of law. You cannot appeal, and because of the principle against double jeopardy, you cannot ask for a retrial. In the years 2018-2019, there were 3 cases. In the year 2022 October, in relation to the 3 cases, the CA has come up with a ruling saying that there has been an error of law and it is urgently requiring redress. And then another point is that when the CFI is to deal with a case concerning national security, then a panel of 3 judges will be formed. If the court comes to the decision that the case against the defendant has not been established, even though there may be an error of law, the prosecution cannot appeal. There may be miscarriage of justice. Article 7 of the NSL has already said that the Hong Kong SAR shall complete as early as possible legislation for safeguarding national security as stipulated in the Basic Law of Hong Kong SAR and shall refine relevant laws. The second loophole has yet to be sort of exploited, but we should take this opportunity to deal with the lacuna, which is similar in nature, but in fact it will be much more serious than the other one. This is right for us to do so because we need to refine our local laws so as to address the problems encountered during the implementation of the NSL. It means that we are honoring our duties to safeguard national security. Madam Deputy, I wasn't on the Bills Committee. Like other members, I'm concerned about the explanation and publicity of the bill. People with ulterior motive have been criticizing the government without any substantial evidence. Like in this case, it is said that the amendment of the law will mean that there will be endless appeals in relation to NSL cases. This is misleading. Well, it takes one person to create a rumor, but then it takes million people to address it, to rectify it. I think it is much more time consuming to clarify the rumor, but it doesn't mean that we shouldn't go all out to deal with it. The SJ in his social media account uploaded a total of 10 diagrams trying to use plain language to explain the content of the bill. Of course, we would have liked it to be carried out in a much better way, but still it is a good beginning. Other than the social media of the SJ himself, can we not make use of other channels and resort to infographics to explain the matter? A lot of time has been spent on producing the infographics. I think the administration should build on it. I look forward to better publicity and public education in promoting the bill. There should be breakthroughs. You should try your best to spread the right messages so that we won't allow such wrong messages to be spread. Thank you. Dr. Priscilla Leung. Madam Deputy, I speak in support of the Criminal Procedures Amendment Bill 2023. This is more than filling the existing legal lacuna. We are also here to safeguard justice, to avoid miscarriage of justice. We are not breaching Article 5 of the Hong Kong NSL. There is anybody who has been finally convicted or acquitted will not be tried or punished again for the act. In other words, in our jargon, it means double jeopardy. Well, we are not sort of eroding this principle. There's no one shall be liable to be tried or punished again for an offense for which he has already been finally convicted or acquitted in judicial proceedings. The key word is finally convicted or acquitted. It means we have gone through all the procedures. Both the defense and the prosecution should have the same reasonable avenue of appeal. The current system is such that under certain circumstances, the prosecution is denied the chance to appeal. As many colleagues have already said, when there is a no case to answer ruling, it means that the prosecution will not have the right to appeal. Under another scenario, there is this verdict or order of acquittal. In both cases, the prosecution cannot appeal. Is it in line with the principles of justice? Many people are not clear about this. They thought that, according to the spirit of the rule of law, if an innocent person is innocent, then he should be acquitted. Common law cherishes the principle of presumption of innocence. We are not eroding this principle. But then sometimes we may think that a person who is guilty is not punished in the right way. In common law, I think there is a principle of procedural justice. In fact, around the world, in some common law jurisdictions, you may think that a certain defendant is the murderer. All the procedures have been gone through, even with a jury in place in the hearing, the defendant has been acquitted, infuriating the public. But then we aren't talking about such cases. We are talking about hearings in which the prosecution believes that there is a high opportunity of getting an appeal, and yet the prosecution hasn't got the right. It is archaic and this should be addressed. I think it is right for us to enhance the system, and this is a right step in cherishing the common law heritage. Well, in fact, appeal is already allowed after the UK has reformed it. And for Singapore, again, in the Criminal Procedure Code, it has already given the prosecutor the right to lodge an appeal concerning a sort of ruling in the preliminary hearing. Well, for the Singaporean Criminal Procedure Code, it is said that a factual issue, a legal issue, or a combination of both may give the prosecution present a case concerning legal issues. National security is, of course, something of huge public interest. People may wonder whether this means that the new provisions would apply to hearings that have already started before the bill has been introduced to the legislature. Would it be against the common law principles? I think the government should use plain language to explain the matter to the public. Once again, we are not violating the principle of non-retrospectivity. But then for procedures that have started before the bill and yet come to the stage of making a ruling on no case to answer, etc., then for such ongoing cases and upon passage of the bill, then of course such cases will be subject to the amended criminal procedures. And then for cases that have already been started and yet the ruling, verdict, and orders only come up after the passage of the bill. That's the requirement. So once again, we are honoring the principle of non-retrospectivity. Others are saying that the prosecution can have an infinite number of times to prosecute a defendant until the defendant is convicted. This is an unfair accusation. Article 5 of the NSL talks about finally convicted or acquitted. Even with the amendment, it will be the Court of Appeal that would make a determination. So in the light of the rationale put forward by the DOJ, DC will come to a decision, or if the DOJ thinks that there's no chance of securing a conviction, the appeal may be abandoned. Moreover, the DOJ has to come up with an acquittal guarantee. I think this is important to notice that, and we can rebut the wrongful accusations. People may think that this is the same as presumption of innocence. Presumption of innocence means that under a common law, before any conviction, the defendant is assumed to be or presumed to be innocent. But then when it comes to acquittal guarantee, it means that if the CA refuses to grant leave to appeal, then the original status will be restored. In other words, the defendant will be acquitted. So there will be such a guarantee. In fact, in Hong Kong, we always like to give double guarantees. In other words, we are not trying to secure a conviction by whatever means, and we need to have trust in the judiciary. We have been throwing a number of legal jargons. It will be difficult for the layman to understand. And for colleagues here, I think if you read the English version, then it's much easier to understand the matter than reading the Chinese version. I had the experience of taking part in bilingual drafting for 7 long years before the return of Hong Kong to our motherland. Well, I found it difficult to understand the text of the bill. It's better for the administration to use plain language to explain the matter to the public. Otherwise, the public would find it difficult to understand. Foreign lawyers, foreign governments may deliberately or unintentionally mislead others having read the text. So I think for the Chinese version, it is difficult not to have misunderstanding. I have to read both versions before I can have a full understanding. So for the legal profession, everybody says that we need to go to the English version. So this is something we need to address. So we're upholding justice. For those that are innocent, they will be acquitted. For others who are guilty, they will be convicted. And that means that everybody is equal before the law. Thank you.
Mr. Tommy Chung, Madam Deputy, the Criminal Procedure Amendment Bill 2023 aims at introducing a new mechanism for appeal. At present, the prosecution cannot lodge an appeal in case a judge erroneously make a no case to answer ruling or a wrong acquittal. This will lead to injustice, and therefore this council is duty bound to address such loopholes. In a criminal case handled by the CFI, there is a jury. All the cases ruled by the jury to be and lead to acquittal will mean that the prosecution cannot lodge an appeal against it. And this is a common law principle. This is not controversial. And this bill would not affect this principle in any way. Before the judge give a direction to the jury for a verdict, there are different stages, including after the introduction of the evidence of the prosecution or the defense, the judge may, due to some erroneous reasons, come to a ruling that there is insufficient evidence and the defendant has no case to answer, and the judge would direct the jury to acquit the defendant. According to the existing system, there's no appeal channel for the prosecution, and the defendant cannot be tried again, leading to injustice. In 2021, there were 3 cases involving syndicated drug trafficking cases. The defendants were acquitted as the judge made a no case to answer ruling, and the Secretary for Justice appealed to the Court of Appeal on through case of this stated, and the trial judge erroneously assumed the role of a jury, but there was no appeal channel, and this loophole must be plugged now. According to the UK Criminal Justice Act 2003, reform has been carried out to address this problem. The bill will also address another type of case, and that is when there's a Hong Kong national security law cases, and where the secretary issue a certificate that the trial should be without a jury, and before the introduction of the NSL, there's no such a procedure for cases tried in the CFA. Therefore, we need to address this new situation, and that is without a jury. An NSL case tried in the Court of Appeal, and the judges erroneously make an order of acquittal, then the prosecution may not lodge an appeal on the grounds of errors in law. There will be national security risks arising from such a wrongful judgment. In the magistrate's court and in the district court where there is no jury, the prosecution can lodge an appeal against an order of acquittal. According to our judicial system, the appeal against acquittals in the magistrate's court and district court is well established. And there's no reason why we should have an exception for NSL cases in the CFI. The loopholes must be plugged. under the magistrate's ordinance and the district court ordinances, there's a mechanism for their prosecution to appeal. And this bill we are looking at it will have a similar mechanism. And the appellate court would have to be satisfied that the no case to answer ruling made by the CFA judge involves an important legal error. And only when this is confirmed that the ruling will be reversed. If the CFA make an error in interpreting the law or makes an unreasonable order, or if the ruling on the facts is someone that a judge will not make, a reasonable judge will not make even after properly directed himself. So we need to consider the reasonable safeguard for human rights. The amendments in this bill are appropriate and timely. With this remark, I support the Criminal Procedure Amendment Bill 2023. Mr. Stanning, Madam Deputy, I speak in support of the Criminal Procedure Amendment Bill 2023. Madam Deputy, after the bill is tabled, in the past, there was some comments in the community that the police would apprehend the wrongdoer, but the court will acquit the same wrongdoer later. So people have doubts about judicial justice. In the past, some legal practitioners collude with the criminals, and even the bar associations have members who are sympathizing with the offenders. We, of course, do not know the details. We are concerned that some judges may, due to his or her own ideology, acquit the defendant in these cases, and the prosecution has no redress. There's no redress to lodge an appeal. This is not what we want to see. The amendments to the bill are for plugging the loophole in some CFI cases. Many members have spoken on the so-called lacuna or loopholes. I won't repeat the points made by so many members. To some extent, in terms of the criminal justice system and as well as national security law cases, we need to improve the system further to address people's worries and concerns, and there should be a further gatekeeping mechanism. We need more safeguards for national security law cases. We are not saying that the judges deliberately acquit the defendants in such cases. It may be due to the lack of understanding of judges, or they may have a weak awareness of the importance of certain cases. For example, in a case involving the hiring of an overseas lawyer in an NSL case, and the judge approved the application by usurping another authority, another party's authority, and therefore we need to have an amendment to the procedural law. As a matter of fact, for cases tried in the district court, the prosecution does have an appeal channel for acquittals. Therefore, we are now aligning the CFI cases with these district court cases in terms of their prosecution's right to appeal. We should have very strict and stringent rules on such cases in the CFI. If there is an error made by the court, And if an NSL case defendant is acquitted due to an error in law, there will be a threat to the national security, and amending the law after the acquittal is not helpful. Therefore, the bill allows the prosecution to lodge an appeal on acquittal made in relation to national security law cases in the CFI. This is appropriate and necessary. I have to stress that the amendment will not affect the fairness in the judicial system. The right to appeal by the prosecution is not going to interfere with the court's independence. In fact, the appellate court can take another look at the relevant ruling that would improve the system and also the quality of the judgment of NSL cases. FTI and I fully support the bill. We need to plug the loopholes and improve the NSL system. I hope members can accept the amendments. So I speak.
Mr. Andrew Lam. Madam Deputy, rule of law is key to safeguarding national security, ensuring social stability, and supporting economic development, so that under one country, two systems principle, Hong Kong can maintain its edge. In the end of last year, the Court of Appeal handed down a judgment in relation to an appeal case because of an error of the trial judge at the Court of First Instance. There was no case to answer ruling, leading to the defendant being released before the jury could consider the case. Under the current ordinance, the prosecution is not given an avenue to appeal. The administration is of the view that the law should be urgently amended. This is not an amendment based on a potential risk, but rather the problem in the reality. Be it no case to answer appeal or NSL 46 appeal proposals, we find the same legal lacunae. There is no avenue for the prosecution to appeal against a possible error made by the judicial system. It is hard for the public to understand the existence of this glaring loophole. In the beginning of this year, the administration acted quickly. Having consulted the public, the proposal was floated to the panel on administration of justice and legal services in order to plug the loophole as quickly as possible. As a member of this Bills committee, I find this amendment necessary. It should be proceeded with as quickly as possible. And yet, we need to be very careful as well. Apart from considering the details of the bill, including the drafting aspects, we also need to consider whether an undue and disproportionate impact will be brought on the rights of the defendants. We urge the administration to clarify a number of matters. For example, Section AAC under Cap 221. In relation to the time limit for the prosecution to lodge an appeal, there is uncertainty, and we question whether there is unfairness. And also for restriction on reports of appeal proceedings under 81AC, does it affect the public's right to know, and whether it covers reports or information published outside of Hong Kong and over the internet. For 923A, the court may award costs to the Secretary for Justice. Does it mean that the defendant will have to shoulder the burden of or pay for the injustice of the system? Through the effective conduct of the Bills committee meetings, the Department of Justice was able to address all these issues directly and provided us with answers. The bill has made reference to the other common law jurisdictions and provided comprehensive safeguards. and also the safeguard of the principle against double jeopardy, so that justice is seen to be done in the criminal procedures in Hong Kong. This is an important step in our legal system. Be it the Department of Justice or the Legislative Council, we are all tasked to improve the legal system in Hong Kong so as to bolster our status as an international financial center for the long-term development, prosperity, stability of Hong Kong, and the national security. I support the Criminal Procedure Amendment Bill 2023. Mr. Edmund Wong, Madam Deputy, the principle against double jeopardy, the presumption of innocence. These are important principles safeguarded by the Hong Kong Bill of Rights. However, there are also people with ulterior motive smearing the Criminal Procedure Amendment Bill 2023, the bill we're currently discussing. They say that they sling mud against the appeal proposals in the amendment bill. They accuse the amendment bill of contravening the principle against double jeopardy, so that the NSL offenders will be sought after by the prosecution and that they will be tried again and again until a conviction is secured. We need to condemn these unfounded accusations and protect the government. First, when the Hong Kong national security law was enacted for the protection of state secrets, in protection of safety of jurors, prevention of injustice, Article 46 of the Hong Kong NSL provides that the cases may be tried without a jury by a panel of 3 judges at the court of first instance if the case involves danger to national security. Now, for a case tried with a jury, and the defendant, if convicted, can lodge an appeal against either the conviction or sentencing. But if the defendant is acquitted, there is no mechanism for the prosecution to lodge an appeal against this decision. This amendment bill provides an avenue for the prosecution to appeal against an order of acquittal by the panel judges at the CFI concerning NSL offences, so that both parties can enjoy the same level of rights. There is no justification in accusing the bill of undermining the principle against double jeopardy or destroying our legal system. At the Bills Committee, I raised some queries. In the community, there are many unfounded accusations against this amendment bill, such as the going against the principle against double jeopardy or allowing the prosecution to go incessantly after the defendant. According to the administration, the bill provides that the rights that the defendant and enjoys. The prosecution has the right to appeal, but at the end of the day, the court will consider a basket of factors before deciding whether to grant leave for the prosecution to appeal. The Court of Appeal is therefore the gatekeeper that provides checks and balances. The Hong Kong Bills of Rights Ordinance does not expressly provide for an avenue for the prosecution to appeal against an order or verdict of acquittal against the defendant. This new mechanism only applies to the circumstances mentioned in the bill, and if the bill is passed, cases or orders made in relation to offences endangering national security tried after the bill's enactment will be covered, but not proceedings already commenced. There is no intention for the administration to go against the principle of double jeopardy or going incessantly after the defendants until a conviction is secured. Finally, after the bill has been passed, I hope the administration can step up publicity and education so as to address the public's misunderstanding and concerns. I support the bill.
Dr. Kennedy Wong. Madam Deputy, I speak in support of the Criminal Procedure Amendment Bill 2023. The bill seeks to amend the following so that the prosecution may, in the case of a CFI with a jury, comes to a no case to answer ruling in a criminal case, as well as in the following scenario, that is, a CFI panel without a jury comes to a verdict or order of acquittal. It is necessary to have this amendment. Now, if the CFI judges come to wrongful ruling of no case to answer, then a defendant acquitted by the jury will not be asked to stand trial again. This is a loophole in our criminal justice system. According to the government's information, I think the practice was inherited from the UK. As early as 2003, there was an amendment to plug the loophole. Last year, there was an appeal case, and the court has noticed such a scenario and suggested that we should plug the loophole. According to the existing Criminal Procedure Ordinance, Cap 221, if we have got a CFI panel of 3 judges that rule that a defendant should be acquitted, even though there is an error of law, the prosecution cannot appeal against the verdict or order. And when compared with Section 84 of the District Court Ordinance or Section 105 of the Magistrates Ordinance, there is a difference, because in those 2 cases, you can appeal by way of case stated. So there is an inadequacy here. There's a deficiency. In other words, we cannot uphold procedural justice in the common law system. Moreover, for offenses against national security, when there is a wrongful ruling, and if the prosecution cannot appeal, there may be dire consequences. For the proposed NSL 46 appeal proposal, we can plug the loophole. Generally speaking, the public may not be too clear about the criminal procedures, in particular those involving appeals. Foreign governments, foreign politicians, and organizations may want to make criticisms because of ulterior motive in relation to our legal system. And in fact, there have been some NSL cases being tried in courts. In order to prevent such untrue accusations misleading the public, the government should clarify the position. Now, the prosecution will now have the right to appeal, but still it will be the Court of Appeal that will give consideration to evidence, legal principles, etc., before granting the leave to appeal. And the mechanism would only apply to rulings or orders made after the passage of the bill. Rulings and orders made before the passage of the bill will not be affected. Therefore, the rule of law in Hong Kong will not be affected. But in fact, we are upholding the fairness of our system. Therefore, I spoke in support of the bill as well as the relevant CSAs. Mr. Benson Luke. Madam Deputy, I am a member of the Bills Committee on Criminal Procedure Amendment Bill 2023. I speak in support of the Criminal Procedure Amendment Bill 2023. In the bill, we note that there are 2 proposals so as to plug the legal lacuna, so as to address the possible question of miscarriage of justice. First of all, in relation to criminal hearings with a jury in the court of first instance, a no case to answer ruling can be appealed against. And then under Article 46 of the National Security Law, when we have a court of first instance panel of 3 judges without jury, when there is a verdict or order of acquittal, then, by way of case stated, the prosecution may appeal against the order of verdict. I understand that the current law is that if there's no case to answer, and if the judge is to direct the jury to acquit the defendant, even though there's an obvious error of law, the position of the law is such that the prosecution cannot lodge an appeal. It means that there will be a irreversible miscarriage of justice. The DOJ has come up with a very important argument. That is, miscarriage of justice may arise from the acquittal of the guilty no less than from the prosecution of the innocent. And this is particularly so when we are talking about NSL cases. Now, we should give utmost priority to national security. I agree entirely with such an approach. Anybody who breaches national security should be given a fair trial and they should be convicted if they are guilty. I think it is the common wish of the community to enhance the fairness of our judicial system. I think the proposals are technical amendments. It is legitimate and it is logical. Well, for the amendments, it means that in future the hearings will have fair procedures. There will be procedural justice, and we are not breaching the principle against double jeopardy, and we are not affecting the adjudicating powers of the courts. Moreover, in relation to explaining policies to the public, it should be taken seriously. In this exercise, we are talking about complicated legal issues and a lot of legal jargons. The community at large may not find it easy to understand. For us to make sure that people will embrace the rule of law, in particular young people, we should use plain language, we should use examples, and we should provide statistics so as to explain the development of the issue as well as the facts. Well, we are in a new era and we're making improvements on all fronts concerning governance. And one important task is that we must make sure that we are better equipped to explain public policies to the public so that the people will be reunited with us and that we can make sure that we uphold our reputation of having a sound spirit of rule of law. Thank you.
Mr. Holden Chow, Medical Deputy, I would like to speak in support of the Criminal Procedure Amendment Bill 2023. This bill aims at plugging the existing loophole in the system. We know there was a case in the CFI and the court erroneously made a ruling of no case to answer. And the defendants were released erroneously, leading to injustice. And also in the appellate system, the prosecution was not allowed to appeal by way of case status. Therefore, in order to prop the loophole arising from that case, this bill introduces the relevant amendments to plug the loophole. So as a matter of background, I would like to stress that the appeal by way of case status has all along been applied to cases tried in magistracies and the district court. Therefore, if a case ruling is found to be erroneous in law, then the prosecution will be able to lodge an appeal by way of case status. So these appeals allow for cases tried in the district courts or magistrate court. And also in the UK, they have introduced the Criminal Justice Act to deal with appeals by the prosecution by way of case status. But in Hong Kong, we don't have such a mechanism. Therefore, this bill aims at plugging the loopholes. I support the amendments. I have to stress that the amendments would allow the defendant, the prosecution, to lodge an appeal by way of case status to address the potential judicial injustice arising from such case of judgments. Especially, I'm talking about in NSL cases. And if there's an error in the law and the defendant in an NSL case is acquitted, the injury done to Hong Kong as a whole will be significant. Therefore, we do have an urgent need for the amendments. And I have to point out that when we consider the amendments, in the community and some Western media try to smear the amendments, saying that these amendments will affect our common law system or they would undermine the principle of double jeopardy. Such smearing comments are wrong, and they are trying to make groundless accusations. Actually, the amendments are introduced to plug an existing loophole instead of trying to affect justice. As some members have pointed out, there's a system, there's an arrangement for appeals by way of case data to be lodged. The appellate court will be the gatekeeper for such a procedure. Therefore, we should make it very clear through our discussions and this meeting. With this remark, I support the Criminal Procedure Amendment Bill 2023. Mr. Yim Kong. Thank you, President. Amending the Criminal Procedure Ordinance is an initiative of the SAR government to improve our legal system and also to improve the legal system on addressing NSL cases. This would be a right approach to address our duties in national security law cases. I therefore support the bill. Safeguarding national security is something that should not involve outsiders or other jurisdictions, and the SAR government has a duty to fully and faithfully implement the NSL. Therefore, further improvement to our legal system and plugging our legal loopholes are the duties of the SAR government in discharging their constitutional duties. Because of this will address the possibility of judicial injustice, and that in that the defendant will be acquitted due to legal mistakes. The prosecution can, in respect of acquittal rulings, lodge an appeal in case of certain CFI cases. This would safeguard this justice in our legal procedures. The amendments will further improve the judicial system. It would clarify the prosecution, the Secretary for Justice right to lodge an appeal in certain cases of acquittal, and also to enable the NSL judges in hearing appeals. This would avoid the possibility whereby the defendant would be wrongly acquitted and the loopholes can be plugged. And also the defendant and the prosecution will enjoy equal rights. This will ensure that NSL cases would be tried in a very fair legal system, and the bill showcase the spirit of the rule of law. It would improve our rule of law in Hong Kong. It would ensure better safeguard for both the defendant and the prosecution, and the overall social interest. This will ensure the overall justice. NSL 46 cases may dispense with a jury because of the existing of state secret. But if acquittal is made by the court, there's no prosecution. For the other way round, a ruling of guilty is subject to appeals. The appeal case will be heard by the appellate court. The appeal court will look at the new evidence in considering whether the case should be overruled or not. This would safeguard the core spirit of our legal system. As Confucius put it, criminal justice will not be faithfully complied with if there is injustice. This amendment would improve the appeal system, plug the loopholes, and also making sure that the NSL would be faithfully implemented. This will also do away with uncertainties, and when we enact the Article 23 legislation, this will clarify the law, and our rule of law will enjoy a better foundation, and the rule of law would be even fairer. This would instill confidence in our legal system, and this would provide a very reliable legal protection to turn Hong Kong into a prosperous city again. So I support the bill.
Mr. Bill Tang, thank you, Mr. President. When it comes to Hong Kong national security law, we need to give regard to the actual circumstances and changes in Hong Kong. We need to tell our own stories in our terms so that the public and the media would understand. Before the 30th of June 2020, there were commotions in the streets of Hong Kong. People were anxious. There were doxing acts, other unlawful acts, causing a panic among the public. The public had no confidence in the future of Hong Kong. Hong Kong was once regarded the safest city in the world. No longer was it the case back then. After the Hong Kong national security law came into operation in full on the 30th of June 2020, we see social order being restored. We see people reassured. So that is what is meant by restoring order from chaos. The Hong Kong national security law provided an instant fix to the problem. Now, can we further improve the Hong Kong national security law? As other members have already explained, there is a legal lacuna in the appeal mechanism in certain circumstances. I fully agree that the loopholes should be plugged. As I understand, at the higher levels of courts, such as courts trying cases involving national security, one important element is the jury. The system of the jury means that ordinary people in the street would be enlisted as jurors. After they listen to the evidence adduced by the prosecution, they deliberate on the evidence and make their own decision. There is no need to justify their decision. So in many cases, once the jury arrives at a decision, it is often difficult to understand the rationale behind the jury's decision. So when it comes to the Hong Kong national security law, which is an overarching piece of legislation providing guidance on our government, as well as on the interplay of local legislation, if some cases sparked so many controversies and yet there is no appeal mechanism available, then there is an apparent loophole. This amendment bill can help bolster our rule of law. In the sense that even if the prosecution is allowed to lodge an appeal, the case will be taken to a higher level of court for a ruling. The second point is, if we refer to the important case authorities in the common law system, the important legal principles, so on and so forth, very often the decisions made by the high level of courts will provide precedents and important directions to the lower courts. So we should allow the high courts to be able to provide guiding opinions and rulings for the lower courts to follow. So I think this amendment bill will further enrich the meaning of the rule of law. So we are absolutely in support of the amendment bill. My last point is this. In the community, I've heard about stories of legal counsel assisting the defendants in the selection of jurors. Before the case commences, either party, the defense can reject certain jurors to avoid prejudicing the case. So in some cases, the defense counsel will resort to every means to protect the interests of clients. If they resort to every means possible to interfere with the composition of a jury. So my take is perhaps we should review the jury system once and for all, because justice is not seen to be done. Like I explained just now, the decision of the jury needs no explanation. The jury is only required to tell the court the decision, but not the rationale. When it comes to the rule of law, if we want to safeguard the interests of both the prosecution and the defendant, we need to amend the law. So I support this bill. I hope that this can be implemented as quickly as possible. Reverend Canon Peter Kuhn. Mr. President, the laws should be amended to keep abreast with the times in light of actual circumstances. It is the Hong Kong SAR's constitutional duty to improve the laws of Hong Kong. I support the Criminal Procedure Amendment Bill 2023. The amendment bill comes with good basis and justification. But I think the government should do a good lobbying job and avoid allowing people to put up soft resistance under the pretext of a misunderstanding of the bill. The bill is not easy to understand. For those who are put on the wanted list, or those involved in the Black Hat riot, they sling mud onto the bill, trying to mislead the public into believing that this bill will make sure that the defendants be convicted. After the bill has been passed, I hope the Department of Justice will use a simple and easy to understand language in order to explain to the public the implications of the bill. The department should also address the rumors and misinformation in a timely manner. Mr. Xia Baolong, Director of the Hong Kong and Macau Affairs Office of the State Council, said in a seminar at the beginning of this year that we should not should not just apply the Hong Kong national security law as it is. We should continue to make improvements to keep up with the times. This is a response to the public's aspiration for the effective implementation of the Hong Kong national security law to safeguard stability and prosperity of Hong Kong in the long term, so that we can move towards a new milestone.
Dr. Johnny Ng. Mr. President, as a member of the Bills Committee, I agree that it is necessary to amend the ordinance and there will be benefits. First of all, in relation to the no case to answer appeal proposal, the proposal fills the legal lacuna avoiding miscarriage of justice so that a defendant will not be set free when the judge makes a mistake and the prosecutor cannot appeal. It means that there will be better justice to be administered and it will be more credible. It can also provide for judicial efficiency because the Court of Appeal can decide on whether the case of appeal should be expedited. There will be assurance that there will be upholding of the justice. In relation to the National Security Law 46 appeal proposal, well, it is also addressing a loophole. According to the existing arrangements, when there is a mistake in relation to making a verdict of order of acquittal, the prosecution cannot appeal. I think by having this proposal, we are not jeopardizing human rights, and we can make sure that there will be justice. The proposals are in line with the spirit of the rule of law, so that both prosecution and defense can have the right of appeal. So I spoke in support of the bill. Dr. Hui Simon Lee. Thank you, Mr. President. Well, it is mainly procedural in nature. We are not being unfair or unjust to the defendants. Therefore, I support the relevant proposals. The main highlights of the bill are as follows. First of all, we are trying to address known loopholes. Second, for national security law cases, we are trying to be preemptive. Well, I think we want to guard against loopholes being abused. In the past, for serious criminal cases, there were anomalies affecting the outcome of the case, and those who were guilty were set free, and it's a matter of miscarriage of justice. In October last year, there were a few cases of international drug trafficking, and it has highlighted the problem here. In one case, a few kilograms of cocaine. In another case, it's a matter of drugs to the value of a few $1 million. Well, even though the case was referred to the CA, and it is said that there has been a mistake, but then the jury was directed to acquit the defendant, and then there was miscarriage of justice. I think, as you know, that for criminal cases in the CFI, most of the cases are serious. Usually, we have a judge sitting on the bench with a jury, and the judge will provide guidance on legal points and will direct the jury to make decisions as to whether the defendant is guilty or not. If the judge rules that there's no case to answer and directs the jury to acquit the defendant, then the prosecution cannot appeal against the ruling, and defendants, as a result of such a decision of the court, will be set free and released from court immediately. And of course, they can leave Hong Kong immediately. It has brought about queries against our system. We have to make sure that our system is fair. And that's why we need to amend the ordinance. First of all, as I have said, this is to address the known loophole. It is necessary. By filling the gap, it means that instead of denying the prosecutor the right to appeal against a wrongful ruling of no case to answer, the problem can be addressed. And it will be good to provide for such an system to redress the errors of law committed. And then under the national security law, we have got a similar situation. That is, the verdict or order of acquittal at the present moment is not appealable. Therefore, I would say that the proposals are merely there to plug the loophole in the first case, and in the second case, take a preventive approach. In this way, we are improving criminal justice, and we can avoid the problems we have already encountered. So you can see that by amending our legislation, we are enhancing our criminal justice system, and we are enhancing our safeguards for national security. So I spoke in support of the bill. Thank you.
主席，
Mr. Jeffrey Lam. President, the bill aims at plugging certain legal loopholes and uphold legal justice and enhance the foundation of the rule of law. If a CFI judge makes an erroneous ruling of no case to answer, the prosecution can only refer the matter to the Court of Appeal, but the defendant would not be tried again. And also, according to NSL Article 46, if there are special reasons or if an external element is involved, the Secretary for Justice can issue a certificate so that the case will be tried without jury by a panel of 3 judges. And if the panel of judges make an erroneous ruling of acquittal, the prosecution has no channel of lodging an appeal. Will the judges make mistake? Different judges may consider different legal issues in different ways. We know that in a case of child trafficking in our airport, the judge make a mistake and acquit the defendants and make a ruling of no case to answer. And after that, the defendant were allowed to be on bail as well. Well, the NSL protects the interests of Hong Kong's national security. A wrongful acquittal would do harm to Hong Kong. If there's an obvious mistake committed by the CFI judges, why can't there be an appeal? If the Court of Appeal can never overrule the wrong acquittal, this is just absurd. The amendments would address the judicial unfair situation in that both the defendant and the prosecution can lodge an appeal. This would improve the integrity of our legal system. On behalf of the commercial sector, and I've heard many comments from the sector, I would like to say the bill is supported by us. And I believe the bill would safeguard Hong Kong's interests in safeguarding national interests. With this remark, I support the amendments.
Mr. Paul Tse. President, this is an overdue amendment. On December 28, 2022, there was a ruling, so the Secretary for Justice took swift action. As Professor Priscilla Leung was saying, back in 2003, the UK amended their laws in this regard. This loophole has been around in our criminal justice system for many years. broadly speaking, there was also injustice for the defendant. Many years ago, we were in law school. We learned that a defendant acquitted by a jury would mean the jury would not have to give reasons and there was no avenue for appeal for the prosecution. This has been the position since the 19th century in Hong Kong. Over the past couple of decades, we have seen major changes in the world, terrorist attacks, for example. So even in the UK, they tried to fix an imbalance where the prosecution lacked an avenue for appeal. Because back then, when the defendant lost the case, the defendant could appeal. But when the prosecution lost, appeal was not an option. Now, this may not be easy to follow for the public. So let me try to spell this out. In the criminal justice system, you have the magistrates' courts, the district courts, and we used to have the High Court, the Supreme Court. Now we have the Court of First Instance of the High Court. At the magistrates' court and the district court, you had a magistrate or the judge handing down a ruling with reasons. But then when it comes to the Court of First Instance, you have jury trials. The jury does not have to give reasons for acquitting a defendant in a criminal case. So there's no way to tell what the thought process is like for the jury. Now, we've heard about the judge's instructions to a jury. The judge tells the jury about the fact of the case and the legal principles, what to look out for. Now, the way to be attached to different kinds of evidence. All these constitute instructions from a judge to the jury. If there are omissions or something's wrong with the judge's instructions, that becomes the ground for appeal. So that's something for the prosecution to rely on in lodging an appeal, or rather for the defendant to lodge an appeal. But this is not open to the prosecution. So something's wrong with the evidence, or let's look at the cases we looked at, cases of international dimensions, when there is evidence that a reasonable person would see that one from Honduras, two from India, and one from the US. These are the defendants involved in the cases. They claim they were wooed into carrying suitcases containing drugs. They pled ignorance. But that's what you see in drug trafficking cases. The defendants always claim ignorance. In these three cases, you have one female judge and a male judge. These judges heard the prosecution's evidence and then erroneously thought that some evidence was admissible, or erroneously thought that the prosecution's case was too weak. Of course, the judge can direct a jury in some cases, but on questions of fact, whether a defendant should be trusted, that's for the jury. The jury simply decides whether to trust the defendant. No need to give reasons. If the jury is not convinced, then that's a different story. But in this case, the female judge and the male judge made the error of considering the cases, that is, the prosecution's case, to be too weak to proceed. So they aborted, or rather called off, and stopped the trial at that point. That's why the three very senior judges at the Court of Appeal concluded that it was time to fix this problem. The Secretary for Justice had to do something. In a way, this is taking away some rights of the defendant. In the past, the defendant in the criminal trial would face no risk of appeal if acquittal happened. But now we're balancing things. In no case to answer rulings, appeal is not open to the prosecution. But now we're trying to fix this imbalance. The approach we take now is a common sense approach. In the past, the criminal justice system was in the defendant's favor. This is not wrong, but that involved a choice. The principle was that it was better to let 9 criminal people get away rather than wrong an innocent person. So the principle back then was to put things in the defendant's favor. Now we are balancing things out. So we're taking the right approach. So in principle, I support this bill. And I commend the Department of Justice for its swift action. We have seen more than just these 3 cases of miscarriage of justice. It's just that the other cases were not as glaring as these 3 cases. One case, 1,420 grams of drugs, $2.14 million in worth. And then we had another case of ketamine worth $3 million. And then another case involving cocaine worth millions of dollars. The defendants were acquitted and they flew off on the same day. So there was pressure on the DOJ to take swift action, and that the DOJ did. But there is something off with the timing, because we now have a national security case going on. It involves a media tycoon. And there will also be some other national security cases coming along. Now, in national security cases, we will see a 3-judge panel without a jury. So we don't have to worry about no case to answer in that regard. Cases at the magistrate's court or district court, when there is no jury, the judge has to give the reasons for their rulings. But now, in national security cases, when a 3-judge panel sits on the case, over the case, the ruling needs to come with reasons. Both the prosecution and the defendant can appeal the case. And there's now the option of by way of case stated. So we're simply applying what's already existing at the district court level, at the magistrate court level, and we apply that to the high court. When you have a 3-judge panel, you can have an appeal based on the law or the facts. So adopting this appeal mechanism for by way of case stated is in line with common sense. It's just that there is something off with the timing. I doubt it would happen, that is, no case or answer will happen with national security cases. And there's another thing I take issue with, the commencement date. For national security cases, the gazette happens and then the mechanism will take effect. But then for the other mechanism, more procedures are involving more subsidiary legislation. So that gives people the false impression that when it comes to national security cases, we take swift action. But for the other cases, we drag our feet. So I hope the Department of Justice can implement the 2 mechanisms swiftly, so that we do not create a false impression that we're taking swift action just for national security cases. That's not what we want to make people think. This kind of impression will be unfair to Hong Kong's legal system.
Mr. Junius Ho. President, a number of members have covered different areas, including background reasons for the amendment as because of the mistake of one judge. The price was paid by the entire society. This is far from ideal. That's why we have this legislative amendment we want to make immediate remedy out of human error. We've been talking about jargons like no case to answer. Those watching TV or the general public may not know what is going on. In short, under common law in a criminal trial, when it is a serious case, say murder, assault causing grievous bodily harm, rape, is a trial by jury. The function of a jury is to judge on facts, that is, whether to accept their version of the event. The judge is an adjudicator on the law and to provide explanations as necessary. A lot of information will flow around in the trial. Well, is the information right or wrong? Is for someone to decide. Say, for example, the prosecution's case does not stand. So there is no prima facie case, and it doesn't warrant the defense to say anything. Then the judge can rule no case to answer. The judge will make a decision. In a normal society, a society with high moral values, it's very unlikely that the judge will make a mistake, but to err is human. If it's an inadvertent mistake, of course, we understand that. But sometimes we see outrageous mistakes. Say, you wonder whether that person accepted bribes or there are problems with that person's political stance. So for A, Roman 1 is in relation to serious mistakes. And A2 is relating to national security cases. Even with a panel of 3 judges, if the person's political stance is dubious and the judges say there is no case to answer when the evidence is strong, then we need to resort to the avenue provided by the legislative amendment. Ms. Priscilla Leung talked about the Criminal Justice Act in the UK. It was an amendment of a similar nature in 2003. We haven't done anything because it has been smooth sail the whole time, so we have not been aware of the consequences. But in a recent case, the judge ruled no case to answer in the face of an enormous amount of drugs. It's an outrageous mistake on the part of the judge. But under the current judicial system, there is no avenue to remedy this mistake. In national security cases, it's also the judge to make a ruling without a jury. We see that the judge in question has left. In the face of such serious mistakes, it will be our own fault if we do not do anything. I commend the Department of Justice for working so speedily, and we all fully support their work. I'm not going to be long-winded. Under Article 84 of the Basic Law, the principle of trial by jury previously practiced shall be maintained. Now, we make remedy of an error of judgment on the part of the judge. Yes, the basic law states that the principle of trial by jury shall be maintained, but there is a gaping flaw. Before the promulgation of the national security law, a lot of people in the street was what? Well, if it's a property, it's been renovated, and if it's a person, well, they've been punished, and I was stabbed. What are the offenses involved? Under the Criminal Procedure Ordinance is assault occasioning serious bodily harm. And there is an alternative charge, attempted murder. Maximum penalty is a life sentence. But when it comes to a difference in political stance, what happened? The defendant may plead guilty to one charge and not the other one, because they would only plead guilty to assault occasioning actual bodily harm, because it only attracts a limited period of imprisonment, but for attempted murder is life imprisonment. Why do I mention this? In a time of political turmoil, that you only look at the person's color, not the facts. You look at whether the person is yellow or blue. If it's trial by jury, if the jury rules that it's an acquittal, there is nothing you can do. But for a judge, ruling no case to answer is a human error. Yes, there is something we can do, but if it's down to empaneling a jury, it's for people to choose the juror, we will have similar mistakes. That's why last week I took the chance to say that when it comes to the Crown, Her Majesty, we still find these references in our law. It's treated as relics, treasure in our Criminal Procedure Ordinance. Why? We're here to plug this loophole. And we may as well use the chance to plug another loophole. Yes, Article 86 talks about principle of trial by jury being maintained. How do we make remedy? I asked the Department of Justice to plug the loophole. I speak to support the Criminal Procedure Amendment Bill 2023. Ms. Lillian Kwok. Thank you, President. I speak in support of the Criminal Procedure Amendment Bill 2023. The bill seeks to address the lacuna in the existing system and to introduce an appeal mechanism under which the under which when the judge makes a ruling of no case to answer, the Secretary for Justice may make an appeal. And in national security cases, an appeal may be made by way of a case stated. Under the existing system, when there is a no case ruling in the district court, the prosecution may lodge an appeal. However, when it comes to high court cases, there is no such power on the part of the Secretary for Justice, that is the prosecution. Is it reasonable? In a high court, judges are human too, so we can't guarantee that they will not make mistakes. If a mistake is made and there is no avenue for an appeal, how can we uphold justice? So we have two glaring loopholes. If they cannot be plugged in time, it will affect Hong Kong's judicial independence and system. When it comes to national security, which is a very important issue, we need to uphold justice. And I have some observations to make. First, the introduction of an appeal mechanism, I think, is in line with the spirit of the rule of law, because the prosecution and the defense will both have the avenue to an appeal. And in a case in 2019 and in one in 2020, the judge in the court of first instance ruled that there is no prima facie case and directed the jury to acquit the defendant. And under the current system, the prosecution may refer the case to a higher level, but the defendants have all left Hong Kong. And in 2022, in a higher level of court, the judges ruled that, yes, there was a serious mistakes made by the trial judge. And the Court of Appeal also said that it's only when a case of no answer is made that the Secretary of Justice can refer the case, and they see an urgent need to reform. Just now, Mr. Junius Ho touched on this point. He talked about the role of a jury. How do they decide the evidential value of the evidence? How do you make sure that they will not make a mistake on facts of the case and arrived at an erroneous ruling or judgment? So we need to think about how to maintain how to ensure the quality of the jury. Defendants should receive a fair trial. There is the introduction of case stated to address the issue. This is about serious criminal cases and cases endangering national security. It's of great public interest. We need to garner public support. The Department of Justice should up their publicity to explain to the public about the judicial reform. Say they can appear on radio shows, or they can ask well-known personalities to talk on these shows about the basic law, about general legal issues, so that the general public will understand that a robust judicial system is good for society. I think the administration we need to do more in this respect. Mr. Xia Baolong said in an opening ceremony that he has high expectations of the basic law education and rule of law education in Hong Kong. And I think this will lend support to the sound foundation of basic law. And in the 2020 Rule of Law Index by the World Justice Project, Hong Kong ranks quite high in East Asia and Pacific region. We rank 6th.
It shows that under the one country, two systems, our judicial system is still highly recognized. We take this chance now to improve local legislation. This is the duty of the Hong Kong government, and it also updates our law. We need to maintain a robust foundation for rule of law, and a stable environment will give confidence to investors and is also conducive to an environment that is good for living, work, and study. And this will be good for Hong Kong's long-term development. I speak to support the bill. Thank you.
Does any other member wish to speak? If not, I now call upon the Secretary for Justice to reply, then the debate will come to a close. Secretary. President, first of all, I thank the Chairman of the Bills Committee on Criminal Procedure Amendments Bill 2023, Ms. Eunice Yung, the Deputy Chairperson, Ms. Carmen Kan, other members of the Bills Committee, and also the Legislative Council Secretariat for their effort so that we can complete the scrutiny work in time. The BC has discussed the contents of the bill in depth and invaluable views were raised. I thank the AJLSP stakeholders as well as the legal sector on their invaluable views and support of the bill. Having carefully considered the views canvassed, we will propose an amendment, which I will explain later. As mentioned by all the members correctly, under the present criminal trial regime, when rulings are made by the court of first instance that a defendant has no case to answer in criminal trials with a jury, or verdicts or orders of acquittal are given in cases concerning offences endangering national security tried in CFI without a jury by a panel of 3 judges under Article 46 of the law of the Hong Kong NSL. Even if there is an error of law, there is no way that the prosecution can lodge an appeal with the Court of Appeal. The bill seeks to address the above situations by amending Criminal Procedure Ordinance Cap 221 to set out 2 appeal procedures so that the prosecution can lodge an appeal against no case to answer rulings made by the CFI in criminal trials with a jury and verdicts or orders of acquittal given in cases concerning offences under Article 46 of the NSL. Now, whether the trial judge or court has committed an error of law will be determined by the Court of Final Appeal. Now, without the mechanism, the prosecution has to apply for a leave to appeal with the Court of Final Appeal. Now, when the trial is adjourned pending a decision by the court, the no case ruling would have no effect. Now, when the prosecution is not granted with leave to appeal, or if we abandon an appeal, the defendants must be acquitted. Now, the Court of Appeal can only reverse or modify the verdict or ruling when it is satisfied that there is an error in law. Otherwise, the defendant has to be acquitted. Now, to prevent prejudice against the jury and the defendants by negative or improper reports and to ensure justice of the trial, the bill seeks to impose restrictions on reporting concerning the legal proceedings of the appeal. When the legal proceedings is completed, the restriction would be lifted. And also the court can relax the restriction depending on the situation. Now, under the appeal mechanism of NSL Article 46, as well as the District Court Ordinance and Magistrates Ordinance, appeal may be made by way of case stated, and it is only restricted to legal matters. According to case laws, an error of law includes a perverse conclusion or finding of facts that no reasonable judge, applying his mind to the proper considerations and giving himself the proper directions, could have come to. Now, while pending appeal, We must maintain status quo of the defendants, otherwise we will render the appeal mechanism meaningless. The bill seeks to empower the trial courts and the Court of Appeal to order detention for the defendants or allow bail. If the court is satisfied that there is sufficient ground to interfere with the not guilty verdicts or order, it must reverse the order and order the trial to be resumed or the defendants retrialed. Otherwise, the appeal must be denied. Now, on the 12th and 13th of June, the Bills committees have met with the DOJ twice and scrutinized the bill in detail. I'm pleased that members give their support to the bill, which effectively fill the legal lacunae caused by a lack of appeal mechanism for the prosecution. And also in the spirit of law, there should be an appeal mechanism for both the prosecution and the defense. As a result, the bill will enhance the criminal procedures in Hong Kong and enhance procedural justice. Now, I will highlight the more controversial issues under the bill. Now, there are views that the bill has not set a time limit concerning the prosecution's decision to lodge an appeal against no case ruling. Now, under the mechanism proposed under the bill, after the trial court has issued a no case order, or after the adjournment period has ended, the prosecution must take the action specified under the new clause 80, new section 81AAC(4) in the ordinance as soon as practicable. That is, to inform the court of the prosecution's intention to lodge an appeal. Now, after the adjournment period ends, the no case ruling's effect would be resumed immediately. Now, the CFI judge, after rendering a no case to answer verdict, normally the jury would be directed to announce a not guilty verdict immediately. If the jury has retired, then they would be summoned back and directed to announce a not guilty verdict. If the prosecution intends to lodge an appeal, it has to act quickly before that. Otherwise, the defendant, which has been released, cannot be retrialed. It is a very urgent situation for the prosecution, and also for the prosecution, it doesn't do the prosecution any good by delaying to make a decision on appeal. If the prosecution informs the court that it intends to lodge an appeal against no case ruling, then the trial would be adjourned. The longer the adjournment, it would be less likely for the same jury to try the case, because the longer the adjournment period, the higher risk that the jury cannot remember all the evidence tendered. Now, in operation, when considering whether an appeal will be lodged, it depends on the complexity of the case. For example, if a case is prosecuted by a counsel on fiat, the counsel on fiat will need time to report the facts of the case to the DOJ and seek instruction on whether to lodge an appeal. Very likely, an adjournment application will be made. We haven't set a time limit for prosecution to lodge an appeal, but rather specifies that it must be made as soon as possible or practicable. This is to provide flexibility to meet the requirements of every case. Now, there are views that during the period pending appeal for cases under Article 46 of the Hong Kong NSL, how we will deal with the personal freedom of acquitted defendants. We have to maintain status quo for the defendants. Otherwise, if the defendants abscond or commit further acts to endanger national security, it will render the appeal mechanism meaningless. Now, since the case involves endangering national security, whether bail is granted must be considered in the context of the Hong Kong NSL Article 42. As mentioned by the CF Court of Final Appeal in the case of Jimmy Lai, it is of utmost importance to safeguard national safety and prevent and curb acts which will endanger national security. It explains why there is a more stringent bail standard under the Hong Kong NSL. Still, I emphasize that under the proposed appeal mechanism, courts can decide whether bail would be granted to defendants during the adjournment in accordance with the local law rather than a mandatory detention. There are concerns that whether under the appeal mechanism, the DOJ can lodge endless appeals until the defendant is convicted. I must emphasize that the bill only empower the prosecution to lodge an appeal so that the Court of Appeal has a chance to review and rectify, where necessary, error of law committed by trial courts. The determination and also whether an order to resume trial is issued by the court would be up to the Court of Appeal after listening to the rationales put forward by both sides. Now, if the Court of Appeal decides to reject the appeal application, unless in accordance with CFA Ordinance Cap 484, the prosecution can prove that there are major and broad points of law pertaining to the decision of the case, or if it is shown that there is substantial or serious misjustice. Otherwise, the prosecution proceedings would end. There would be no abuse by the prosecution. Now, there are views concerning that the two new appeal mechanisms will apply on cases which have started before the bill is passed, whether it is in contravention of the no retroactivity principle. I emphasize that the legislative proposal only seeks to amend the legal proceedings concerning criminal procedure rather than offenses or penalties. It only applies to verdicts, judgment, or orders made after the passage of the bill rather than those before. It will not be in contravention of Bill of Rights Article 12, that is, no retrospective criminal offenses or penalties pending trial. Now, the new mechanism will apply to cases pending trial, in trial, and pending verdicts. It is in line with the common law principle, and it is not an injustice to defendants. The amendments will not affect the existing rights of the defendants, nor undermine the opportunities to fair trial and the presumption of innocence. I will move an amendment at the CSA stage, and I will explain the amendments later. I'm pleased to learn that there is no objection on behalf of the BC. Now, Mr. Paul Jia raised a question. I would like to reply to his question. That is, after the passage of the bill, when will the appeal mechanism come into effect? Now, subject to the passage of the bill, the provisions in relation to HKNSL 46 will come into effect on the date when the ordinance is gazetted. Now, this is about the appeal by way of case-dated mechanism. The mechanism is sophisticated. We don't have to legislate in the form of subsidiary legislation for the mechanism. Now, for provisions which are in relation to appeal against no case ruling, it will come into effect on a date when, as specified by the Secretary for Justice by way of Gazette. Now, the government will work with the judiciary to work on the subsidiary legislation and also the operational details. After the subsidiary legislation is drafted and passed, the mechanism will come into effect together with the subsidiary legislation. Now, this is because we have to work with the judiciary to work on that. As a result, they will not come into effect immediately. President, I so submit. I implore members to support the second reading of the bill and also the amendments to be moved by me. Thank you, President.
I now put the question to you that the Criminal Procedure Amendment Bill 2023 be read the second time. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Criminal Procedure Amendment Bill 2023. This council now becomes Committee of the Whole Council to